It is August the 14th of 2026, and this is the Court Gallery. We kick things off in Judge Hesselink's family court, where a mother explains her failure to appear is due to debilitating anxiety. But the judge just needs her to find a way to comply with court orders. Then, another man facing a nearly $11,000 child support debt learns from Judge Hesselink that a $50 payment is more of an insult than an effort. And finally, we move to Judge Elmore's criminal court for a powerful sentencing, where a defendant's long and troubled history is laid bare before the judge hands down a sentence that proves some lines can't be uncrossed. All that and more starts right now.
Nigel Ingersoll and Cassandra Ingersoll, file 23-19438-DM. I do see Mr. Ingersoll with Mr. Trush is present, and Cassandra Ingersoll is with us as well. Ms. Krause, is this yours?
It is, Your Honor.
Can you update me as to this one, please?
For the in regards to the Cassandra one, this was a hearing for the defendant on her failure to appear and a show cause for her. And then additionally, I think it's just no, that's it. It's for her failure to appear at the last hearing.
All right, thank you. Ms. Ingersoll, there's an order to show cause against you that indicates that you failed to appear for a scheduled review hearing on July the 10th at 1:30. You understand that allegation?
Yes, sir.
The failure to appear when you've been ordered to appear by the court can be punishable by contempt of court, which could include at a maximum 93 days in jail and or a $7,500 fine. You have the right to have a hearing if you wish to disagree with that. At the hearing, you could represent yourself. You could retain your own attorney. You do not have the right to have a court-appointed attorney. At the hearing, you'd also have the right to see, hear, and question the witnesses. You'd have the right to present your own witnesses and get a subpoena from the court requiring those witnesses to appear and testify. You could testify, or you could choose to remain silent. And if you chose to remain silent, that could not be used against you. The burden of proof would be on the friend of the court's office to prove that you failed to appear, and that would be by a preponderance of the evidence. And then you also have the right to appeal. How do you want to proceed today? Do you want to have an attorney, or do you want to have a hearing? What would you like to do?
I mean, I guess I don't know. I don't understand. I didn't show up because I was physically sick to my stomach. Even right now, I'm shaking. I have so much. I'm sorry?
Did you go to the doctor and get a note indicating that you were unable to appear because you were sick?
No, it's like an anxiety, like PTSD, like being involved with Nigel, seeing Nigel, hearing his voice. All of that puts me in severe anxiety. And I physically couldn't bring myself to log in because I know how he is and I know how he acts. And I couldn't do it. I couldn't. I'm shaking thinking about it right now. Like He gives me so much anxiety, so much PTSD, and the way he is, he lied to you, first of all, at the last, and I've sent in an appeal for that judgment that you made. I've sent in evidence of with my appeal as to why I don't think that that judgment should go through.
Right, and you'll be given an opportunity to do that appeal. I'm not here taking that away from you. You certainly have that ability to appeal if you wish. The only question was why you failed to appear, because the court ordered you to be here and you've been here in the past. I had no choice but to move forward with Mr. Ingersoll's requests and to issue a bench warrant for you, or an order to show cause for you, for your failure to appear.
I understand that. That's why I'm here.
Okay. All right. So the order that you were referring to set some parenting time for the summer, and then alternating holidays moving forward, and then a review hearing in April of 27 to find out what we're going to do about next summer. So that's still in place until and unless there is a change based on your appeal. So you certainly have the right to make your appeal, and I'm not going to stop you from doing that. The only issue is, what do I do about today for your failure to appear last time? The fact that you showed up today is really what the court is trying to get you to do, which is to show up when you're supposed to show up so that the court has access to both sides of the information.
I usually do. I just couldn't. I couldn't even physically speak.
I understand that. So, and the fact that you appeared today shows me that I shouldn't have to worry about you showing up in the future. You may need to speak with a counselor or a therapist of some kind, or have somebody that can sit with you or help you maintain your anxiety at an acceptable level. I'll leave those things to you. But we are doing this in a courtroom, and most of the time we're doing this via Zoom, so you don't have to be in the same room as him. And so that should be some comfort. I understand that,
but he lies to you. He lies to you, and every time we've been together over court, he's lied to you. And every time I try to defend myself, we both get reprimanded. He's a narcissistic, pathological liar.
Ms. Ingersoll, today is not about him. Today is about you.
Okay, well, that is why I didn't show up, because I cannot function with him around, in view, in sight, his voice, anything. He's given me so much PTSD. He's lied so many times to you guys, and you have a plethora of paperwork against him. I shouldn't even be sitting here right now. He should have zero rights to any children. He's abusive, and you have proof of that. He's abusive to women. He's abusive to all of his children.
Ms. Ingersoll,
I'm not going to allow my child to be abused. I'm not going to. You are asking me to go against my motherly instinct and give my child up to somebody who is a proven abuser. I'm not going to do it. I can't. I'm not going to go against my motherly instinct.
We're not here about that today. Ms. Ingersoll.
That is what we're here about. That is exactly what we're here about. I didn't show up because he's a liar. I didn't show up because he is a narcissistic liar.
Ms. Ingersoll?
I couldn't sit in a courtroom and not have something to say.
It's clear to me that you know how to say things.
Not when he's sitting there, because he doesn't allow me, and neither do you.
You're doing it right now.
Yeah, because he's not here to bombard me and interrupt me.
He is here. Ms. Ingersoll, he is here. He's in a panel on my screen, just like he is every other time. So
okay, and any other time we can hear each other and he can talk.
Ms. Ingersoll?
And we can see each other. Listen, I'm telling you, the reason why I didn't show up is because I physically cannot be in his presence. I can't. It makes my chest hurt. It makes my stomach turn. It makes me want to throw up. I'm shaking.
Anything else that you want to tell me before I get a chance to say something?
No, say whatever you want.
Thank you. Please listen carefully. If you had not gone on that rant, what I was going to say was that because you showed up today, I'm not going to take any sanctions against you. It is very clear to me that you are able to speak your mind when you wish to. Mr. Ingersoll and his attorney are present today, just like they have been for every other court hearing. And I have never found you to be unable to speak in his presence in the past. So I will expect you to be at every court hearing in the future. If you wish to make an argument that you believe what he is saying is not true, you will be, like you have in the past, given an opportunity to do that. And I will make a decision in an individual case whether or not I believe him or I believe you. But simply ranting isn't going to get you or anybody else where you need to go. So for today's purposes, there will be no sanction against you because you showed up. In the future, if you fail to show up, I will sanction you then because you have been warned now. Have I made myself clear?
Crystal.
That's all. That's all for today. Thank you very much.
Your Honor, if I may.
Mr. Trush.
I know this isn't exactly what we're here for today, but I mean, I do want to at least address it so that it's clear to everyone. At the last hearing, the court did order 2 weeks of consecutive parenting time to take place in August. I've reached out to Mrs. Ingersoll, and communicated that to her that order is in place. She indicated to me that she intends to appeal that order, which obviously she's welcome to take whatever legal courses are validly available to her then. Frankly, I think she's past her timeline for it, but that's not here nor there right now. By my math, unless that exchange takes place by Monday, there's no way that she could possibly comply with that order, which still remains the valid order of the court at this time. I have indicated to Ms. Ingersoll I am willing to assist in the, making the arrangements for that. But I think I do need to indicate that if the exchange doesn't take place by Monday, we're going to have no recourse other than to file a violation of parenting time with friend of the court, as well as potentially turning over to the state police for kidnapping, custodial interference, for not following the valid order of the court.
Can I say something now, please? Because Richard and I spoke on the phone, and I'm sure it's recorded, and I would love for you, Judge, to hear that recording. I did send an appeal to the friend of the court in writing, which is what I was told to do, and that appeal is dated for the 26th, which my end date was the 31st. So that's in time. I don't know where that appeal would be. I don't know what happened to the envelope, but I sent it out and it was dated for the 26th. So
did you send a copy to Mr. Trush?
I didn't know that Mr. Trush was Nigel's lawyer until after the fact. He called me, he messaged me and said, "Hey, can we be in contact about this?" And I said, "No, sir, I sent in an appeal." I didn't know that Richard was his attorney until after I had sent in the appeal.
Well, now you know that he's the attorney. Would you please send a copy to Mr. Trush? And then
I don't have an exact copy. The friend of the court has the only written copy that I sent. I wrote it in handwriting like I was told to do. A written appeal. I didn't know that I had to do it twice.
How are you going to know what the appeal is if you don't have a copy of it?
Because, I mean, I know what I wrote down on the paper. It's not going to be the exact same wording. I can write everything back down again. I sent in proof of him lying to you in court. I sent in proof of him being abusive, admitting to giving his son bloody noses. I've sent the court a fair amount of evidence to appeal your judgment.
I'm not the one that hears the appeal. You're appealing my order, so it's going to go to a different judge. Okay? So.
Okay, well, I did send in that appeal in time, so I haven't
Great.
Kidnapped
Great.
my own child, the child I've been taking care of for 5 years by myself. How do I kidnap my own child?
Mr. Trush has told you what he intends to do. You've told Mr. Trush what you intend to do. I'm going to wait for everybody to do what they're supposed to do. If there is a violation of the court's order, we'll address that once it happens. That's all for today. Thank you very much.
Thank
Thank you,
you.
Your Honor.
All right, the next matter is Nigel Ingersoll and Krista Carnahan, file 15-15991-DM. This is a support motion by Ms. Carnahan, and then we also have a review on a parenting time issue by Mr. Ingersoll, I believe. So Ms. Carnahan, your matter first. What is it that you would like me to review as to the child support matter?
Riot has a medical bill that I had submitted for his orthodontist. I would like you to take a look at it and see if it could possibly be calculated in along with his child support. It was ordered that Nigel was supposed to pay 76% of Riot's medical. However, he hasn't been helping with anything, so I kind of.
Yep. I think the number was 74% and 26%. 26 for you, 74 for him. But let me hear from him as to how he wishes to proceed. Mr. Trush, as to the support matter and the amount that's been listed for medical services.
I'm sorry, Your Honor.
How does your client wish to proceed? Ms. Carnahan, or excuse me, Ms. Carnahan has listed an amount of extraordinary medical with Dr. Sarya for, looks like $6,550, or actually $6,750 for orthodontics. Typically that would be divided out according to the percentage in the support order at 74 and 26%. Is there some reason why your client does not wish to do that?
Well, Your Honor, for today's purposes, I guess I would just indicate to the court, I mean, I haven't received any of that information or been able to go over it with him yet. That might be partially my fault. I think our original appearance was a limited appearance on the matter, but I haven't received the information to be able to go over it with him. So I would just ask the court to potentially set another hearing where I can go over that with him, discuss whether or not that's appropriate or not, or whether we agree with it or not.
How'd you get notice of today's hearing?
From the court calendar. So to be clear, Your Honor, when I came to the original hearing and took the case on, I went to the court's calendar and docketed all the existing court dates. This court date and time was existing at that time. I think that what was existing was probably the review hearing for the parenting time. Not this particular hearing, but they're set at the same time.
Ms. Carnahan, did you send a copy of your motion on support to Mr. Ingersoll?
Yes.
There's a certificate of mailing at the bottom of this motion. Is that your signature at the bottom?
I'm sorry.
You have that?
Yes.
Yeah,
Yes.
I'm looking at motion regarding support, and it says there's a heading underneath where it says notice of hearing. It says certificate of mailing, and there's a date of
Yes.
7/9/26 and a scribbled signature. I'm assuming that's your signature.
Yes.
It also says hand delivered. So how did you make the service on Mr. Ingersoll?
In his mailbox.
Did you use the post office or did you place it in his mailbox?
No, I just dropped it off.
Did you put a stamp on it and put it in your mailbox so that the post office delivered it to his mailbox, or did you physically go to his mailbox?
I will resend it out through the mail. No, I just went and dropped it off.
So you never gave it to him personally? Is that correct?
No.
All right. He's entitled to notice of this, and if you can't prove that he got the notice, I can't require him to respond to it today. If you had actually delivered it to him, or if you had mailed it to him, then I could require him to respond to it today. But because I can't show that, I will have to have another hearing date set on your request for that. So we will do
All right,
this
I
again.
will.
Okay, so I need you to
I'm sorry.
send a copy of it and then fill out what's called either the certificate of mailing or a note, proof of service, which says I mailed it with a stamp on it at such and such a date, such and such a time. Or if you hand deliver it to him or however you get it to him, I simply need to have proof of that with, so you'd give it to him, and then you'd send a copy of that proof of service that this is how I got it to him, Judge, to the court so they can file it. So I have that for the next hearing. Okay.
Okay.
And Your Honor, with Miss Carnahan's permission, I mean, I can reach out to her after the hearing and give her ways to deliver it to me. I mean, I'm happy to accept service on Mr. Ingersoll's behalf for it.
Thank you very much, Mr. Truce. So Ms. Carnahan, he's trying to make it easy for you. So how do you want to get a hold of each other after the hearing? Mr. Truce, do you have a number for her, or Ms. Carnahan, do you have a number for Mr. Truce?
Yes. Does he have an office in town?
My office is in Grayling, but I mean, I can give you the office phone number.
Why don't you
Yeah,
do
I'd
that
rather-
so she can set it up?
I don't want to put my phone number on
Yeah,
over Zoom.
he'll give you his, which is a public number, so that way you can call him.
What's your number?
It's 989-745-6625.
All right.
Sir, is it possible to get an updated address
What's
for
that?
Mr. Ingersoll, since we have a bunch of return mail that keeps getting sent back?
Absolutely,
Yeah.
but I'm not putting my address online. I'll stop in and provide that for you personally, or I'll call after this is over. No
Please
problem.
do. Thank you.
Yes, ma'am.
All right, so we've got that issue at least preserved, and that we'll deal with that at the next court hearing. The next matter that we have then is a review on parenting time. And what is it that you want me to know about that, Mr. Truce?
Your Honor, essentially since the last hearing, there has not been any parenting time. When we were last here, there was, excuse me if I misstated, but I think it was makeup parenting time that was supposed to happen during Alpenfest. That ultimately didn't happen, and I don't think there's really been any parenting time since then. There is an issue that I do think we need to address about how parenting time is supposed to occur, because this past Sunday, Mr. Ingersoll went to exercise his parenting time. The police were called with an alleged violation of a PPO. And ultimately, there's some question over how this exchange is supposed to take place, given that it sounds like the present state of things that there might be a personal protection order.
So specifically, Mr. Truce, what are you asking for?
Well, I guess at this point, I think this was set again for a review hearing of that prior to today's date already. I think fundamentally what we need to assess here is parenting time has not been happening. And from my position, I don't see a good explanation as to why it's not. What's consistently being told to me is that Riot does not want to engage in the parenting time. I've indicated it before, and I'll continue to indicate it. I don't think that it is good policy-wise to let a 13-year-old drive the bus, so to speak. I also, I would want to know what steps it is that Ms. Carnahan is taking to assure this, because to the extent that she's letting him just say, I don't want to go, and that's the end of it, I don't
Agree on
think
deaths and
it's sufficient.
assets. We do not agree on who claims the children.
Sorry about that. That was another party, not Ms. Carnahan. Go ahead, Mr. Truce.
So I mean, I think that's what we're here for today. I mean, obviously, our request is going to be that makeup parenting time be ordered, and that parenting time actually occur as it's supposed to.
Ms. Carnahan, who is the counselor for Riot?
Hey, I'm from Old Town Psychological. She submitted her letter of recommendation.
Submitted it to who?
She mailed it out on Tuesday. I also received a copy of it.
Mr. Truce, did you get such a letter?
I have not. I've had no communications from the counselor to me. The court did request Mr. Ingersoll to reach out to the counselor. He did that, but was basically told unless he's a client or does an intake with them, they won't talk to him.
I have not received such a letter, Ms. Carnahan. Is Pam here and available for testimony today?
She submitted her request. Other than that, she does not feel comfortable after Nigel called and verbally abused her staff members. It was also wrote in the letter of recommendation.
Well, since I don't have that letter of recommendation, I don't know those things. The hearing was set for today, and it was made very clear that the counselor was to be subpoenaed to be here. And it was also, hang on, let me finish my thought. It was also noted that the parties were to use the counselor and that she was to make interim recommendations as to how things were going with Riot, so that, in Mr. Truce's words, Riot wasn't driving the bus. It was the counselor who was driving the bus. Why did that not occur?
It was submitted that she was supposed to submit in writing, not in person. And she said she does not feel comfortable with the way Nigel called and verbally abused her staff and the confidentiality with it being over Zoom and broadcasted. She wanted to keep Riot's counseling private for the things that have happened.
Then we'll set an in-court hearing. She can be here for that, but you need to subpoena her for that. Mr. Truce needs to have the ability to call her and talk with her about concerns with Riot and parenting time. And parenting time needs to take place. How do you propose that we do all of that?
Your Honor, after the last couple of attempted visits, Riot has refused to go, and he and Riot's counselor does not feel that it's safe. Nigel came over here. He shoved Riot off the porch, tried to drag him to the vehicle. And then last Sunday, he pushed his way into my home. Riot was quite distressed. I took a video of it. And then we have also had false police reports. The police were at my house the other day. Some of Nigel's friends have filed false police reports, and they have been talking to, the police showed up and had to talk to Riot. Riot is, it's just not working. At all my attempts to get Riot to call his father and have an interaction, the interaction is so negative that it has affected him horribly. It's affected his school. It's affected him emotionally. You cannot attempt to have a relationship with your child and put your hands on that child.
All right. What I'm going to do is I'm going to reset today for a future court hearing on the same issue. Ms. Carnahan, you're going to need to subpoena Pam at Old Town. We'll have this hearing in person. I'll set it for a 2-hour hearing. So, Ms. Carnahan, you're going to need to contact Samantha Johnson, who's my scheduling person, to find a 2-hour hearing date for that. And then you're going to need to get a subpoena from the court, which you will fill out, and I will then sign, and that will be given to Pam to require her to attend at that next court hearing. The letter that you've indicated that the counselor has sent out needs to be sent to Mr. Truce as well. So if you have a copy of that, that needs to go to him so that they have access to that information for any questions that they may have for the counselor. And then we will schedule this hearing and have the hearing, and each side will be given a fair opportunity to bring out whatever facts they believe are necessary regarding ongoing parenting time. And I'll reserve making any decisions about how ongoing parenting time is going to look in the future for that hearing. Mr. Truce, do you have any questions about that?
Your Honor, just
Yeah.
in the interim, I mean, is the present order and is it continuing in effect? I mean, should parenting time be continuing to happen? Is the court ordering any makeup parenting time? Because again, there's been a significant amount of missed parenting time. And then lastly, to address how the parenting time exchange should occur, again, given that, and Ms. Carnahan didn't address this, but I don't think she disputed it either, that there's a PPO and we don't want to be dealing with a violation every time that parenting time is attempted.
All of which is a great reason for us to address that at a court hearing where I can adduce facts and have specific information in front of me before I do anything else. So the court order has not been changed. If there are ongoing violations of it, I will address it at the next court hearing. If there are ongoing valid reasons for not complying with it, then I'll see that at the next court hearing. But it's not productive for me to make a decision without facts, and I'm not going to be able to have all of the facts that I need without the counselor testifying. So it's not going to be productive for me to make a stab in the dark. So I'm going to do this all at one time when the counselor is here, the parties are here, and I can hear all of the evidence at the same time, and then I'll make a decision on all of those issues. So Mr. Ingersoll has not lost his ability to have makeup parenting time if I decide that that's appropriate. It's just not going to be immediate. It'll be after the court hearing, and I'll allow him to address any missed parenting time, including from now until the next court hearing, if that's what occurs. If Ms. Carnahan is able to give ongoing parenting time, then there may not be any loss of parenting time. I don't know that. But I'll have the hearing in the future when everybody's here. Ms. Carnahan, do you have any other questions?
No, Your Honor.
Judge, if she calls next week, I will not be here.
Your Honor, I'm sorry, just one additional issue I didn't want to address.
Go ahead.
And again, I don't want to beat a dead horse, but the issue of the PPO and how the exchange should take place in the interim, I would suggest if Ms. Carnahan is agreeable to it, the city PD has indicated to me that their front parking lot is under camera and they do custodial exchanges there for that reason. So I would suggest, at least until we can get another court hearing, that parenting time exchanges take place there so that there is camera footage of everything that happens in case there is, any sort of allegation.
Thank you, Mr. Truce. All right, that'll be the order of the court. Ms. Carnahan, please contact the court to get the court date set and issue the subpoena. And we'll see everybody in court as soon as we can. Thank you. That's all.
Your Honor,
Yes, ma'am.
would we additionally address her support motion at that same hearing?
That's a great idea. Let's do that. We'll let you know when that's going to be set and schedule it together. All right, the next matter is Melissa Klein and Dustin Price. That's file 11-14071-DS. I do see Mr. Price is with us. Ms. Blaine, can you update me on this matter, please?
Yes, sir. This matter was adjourned from July 10th, and the defendant was instructed to make a payment before today's hearing. We started a new support review, and parties were advised that they could discuss any of the amount that was owed to each other and that they had the option to waive that money for if they had an agreement on that. We also received information from Ms. Klein that verified that one of the children was in fact staying with Mr. Price, and that child support for that individual child has been abated. Mr. Price has a support obligation of $889.37, which also includes reimbursement for medical expenses. His current balance on the account is $10,998.85. And we did receive $50 last month.
All right, Mr. Price, what information do you want me to have?
I am still currently working on filing a motion. It is a little delayed because after speaking with my children, they wanted to have an opportunity to try to talk to their mother first to see if there's an easier way to resolve this without going back to court. And she had shut them down every time. So I will be moving forward with filing a motion. But I also will be able to make another payment here next week. I don't know what that amount will be just yet. But I will make another payment next week on payday.
Are we talking $50 or are we talking closer to the $889 that you actually owe each month?
As close as I can get to that number. I still have my mortgage that I have to pay and several other bills. So along with miscellaneous expenses for our oldest daughter who is moving into Michigan State on August 25th. She still has other furniture and things that she needs.
I don't doubt anything that you're telling me, Mr. Price, but those are all things that everybody in the world has bills for.
Yep.
Lots of people have kids moving to college. Lots of people have mortgage payments. Lots of people have bills for medical. All of that stuff is entirely normal.
Yep.
The French court calculation takes all of that into account in dealing with what the child support amount is. So you owe $889 a month. And you owe almost $11,000 in arrearages. If you're not going to be making that on a regular basis, I'm going to have to start thinking about jail. We had this conversation already once, and I gave you an opportunity to make some agreements. Apparently, you weren't able to do that, and I'm not faulting you for do that because I understand it takes two people to agree. But at some point, payments need to be made, and I get it that you disagree with them, but it's still an obligation, and I have a duty to enforce that obligation. So $50 a month doesn't cut it.
Understood.
So unless you want to keep seeing me month after month and having me decide whether you go to jail every month, payments need to be made. So when's the next payment going to be made?
That is going to be next Friday on my payday.
And why is it that you don't know how much the payment is going to be out of that check?
Well, like I said, I'm in our last hearing, I make $16 an hour and I still have a multitude of bills that I have to pay. So I would rather not have my house be foreclosed on or my utilities shut off. So once I get that paycheck, I will be able to determine how much I can pay moving forward.
I think we had this part of the conversation last time as well, Mr. Price, but I want to make sure that you understand what you're flirting with. The question in my mind is, do I need to send you to jail? You're asking about whether or not you owe some money to somebody. Are those two things the same in your mind?
Whether I owe money to somebody or whether I go to jail?
Yes.
I mean, I'm not sure I understand the question.
Let me back up and try to rephrase it then. If you don't pay your bills, at some point in the future, the home or the bank can come and try to repossess your house. That takes a number of months to do it. If you don't pay this bill, you will go to jail for 7 days every month that you don't pay this bill. I would think that you would want to stay out of jail a little bit more than you would want to make your other payments. That's just me. I'm wondering if you have that same mindset.
No, I do have that same mindset, but also maintaining the home that my children still currently reside in and my youngest child resides in 50% of the time during the summer, and they had lived in for the last 5 years is also equally important. I'm trying to juggle both at the same time, and I apologize that it doesn't seem that way.
Oh, I get what you're juggling. I totally understand that, but I just thought you might want to know that my view is that this bill is more important. And because you have not made, you have not made a significant payment after I spent quite a bit of time last month talking with you and not throwing you in jail then, I would have thought that you would have done better than $50.
If I had more,
Go right ahead, sir.
I was going to say, if I had more than $50 to apply towards it, I would have.
My comment, sir, was going to be that quite frankly, $50 is a slap in the face.
Okay, I'm sorry you feel that way, but I've also gotten shut off notices for my power, other things like I did what I could, and apparently that wasn't good enough. So I don't know where we go from here.
Well, where we're going to go from here is 30 days from now, you're going to pay $889, or you are going to go to jail for 7 days. So that will be 2 months that I've given, 2 months then that I've given you to pay your bill. So you make the decisions as to which balls need to stay in the air. You make the decisions as to which bill is more important to you. But I'm telling you, this is what's coming. If you've not made the full payment in 30 days, by the next court hearing that we have, you will go to jail for 7 days. And we're going to do that every month until you figure out how to make your bill payments. Are we clear?
Absolutely.
All right. I'll see you in 30 days. All right, Jessica Schultz and Timothy Bennett, file 24-19620-DS. I do see Ms. Schultz is with us. Do we have Mr. Bennett?
We do not.
All right, Ms. Kraus, can you update me, please?
Yes, this hearing has been adjourned 3 times, most recently from July 10th to monitor good faith payments of support, and was referred to friend of the court for a new support recommendation. The defendant did have contact with the office on August 6th to get the hearing date information for today and was provided that information. He was aware that he did have some conditions that he would need to submit to our office. I've not received anything and have no good address for him on file as well. So he was aware of today's hearing. His obligation is $703 with an arrears balance of $20,342.50. There's been no payment made since the order entered in 2024.
Ms. Schultz, have you had any contact with Mr. Bennett about his child support?
Not with Mr. Bennett directly, no.
Well, with anybody on his behalf?
Not about child support. I know he's not in rehab and it's the same story. He did apply, but I don't think he got approved, and he bought himself time. And he did, you stated a couple months ago that if anybody paid any of his bills on his behalf, 3 days before court last time, which I didn't check his stuff, somebody paid all of his fines off in Jackson County right before our last court date, and I didn't check it. So I don't know where he is, but I know he's in Jackson, Flint, downstate somewhere, bouncing around, and here we are.
All right. Well, for his failure to appear, then I'm going to issue a bench warrant. We'll do the standard 25% of his bond or of his arrearages for bond, and if he wants to get out, he can pay that, and that then will go towards you, towards child support. Is there anything else that you want me to be aware of, ma'am?
No, I just appreciate your time. It's a long, drawn out issue. Thank you.
It is. Yep. Take care. Have a good day. Ms. Kraus, is there anything else that we need to do today?
No, just in regards to that he failed to comply because you gave him specific instructions. As he indicated, he was reapplied into a program that he would receive funds to go towards his support. We did not receive any of that information.
All right. Was this the one that was an issue of abatement or not?
Yes, we are regardless, we are initiating a new support review, which should continue in regards to that. He was supposed to
Yeah, to do a
submit.
medical needs verification
Yep,
and
we,
letter
we do
program.
have some of that information from the prior hearing, but he was to indicate where he was participating, any funds available for any of that type information, and to get information regarding his Social Security disability attorney, because he had indicated he had applied for that as well, but no documentation.
All right. In the documentation you're going to prepare for today's proceedings, would you please make a note that he has failed to supply the documentation he was previously required to submit, and he's failed to appear, so a bench warrant will issue with 25% of his current arrearage amount. Thank you.
Yes.
Ms. Kraus, I'm going to recall the Bennett matter. It appears that he has just appeared today.
Which case? I apologize.
Yep, this is Jessica Schultz and Timothy Bennett. It's file 24-19620-DS. Mr. Bennett, are you with us? Sorry, you're still on mute, sir.
Yeah.
We called your case about 15 minutes ago. Where were you?
I don't know, I just got online.
I know that, but your case was scheduled for 9 o'clock. It's now 20 minutes after. Where were you?
I don't know, I just found your number. I just got, sorry about that.
Well, Ms. Schultz was already here and she's now gone. Ms. Kraus, can you update me again as to this one? Remind me where we're at?
Yes, this hearing had been adjourned 3 times, most recently from July 10th to monitor good faith payments of support, and was referred to our office for a new support recommendation. Additionally, the defendant was to provide documentation on a letterhead in regards to a participation in a program and when funds would be available for the child support obligation. And he was also ordered to provide contact information for their Social Security disability attorney to the friend of the court within 7 days. Friend of the court has recently received return mail, so we have no good address for the defendant and have had no contact outside of him calling the office last week to get information regarding today's hearing.
Okay, I got my new address, and I got my disabilities number. If you want to call them, I just spoke to them yesterday about disability. I'm getting in a month or two. I'm getting disability. I'll be able to pay off the child support then.
Mr. Bennett, you were supposed to provide information to the friend of the court and you failed to do that. Why is that?
I got the number for the disability lawyer right now, if you want it.
You were supposed to have it before today. Yes, we'll take it from you, but you were supposed to have it before today. You were also to provide information about the payment program or the payment possibility through the program that you're in. Where is that information?
I don't know about that program. They've been trying to get hold of them. They won't get a hold of me. I don't know. I guess they're not gonna do it. But my disability is gonna go through. I spoke to them yesterday. It's gonna go through. It's just gonna be a month or two.
What documentation do you have of that?
I got a phone number you can call. My lawyer.
Ms. Kraus, am I remembering correctly that the last time we had a hearing, there was a gentleman that was assisting Mr. Bennett from the program?
Not at the July hearing. It was the prior hearing. I believe it was on May 8th, but he had left that program, and the gentleman that I had spoke to had indicated that he did not want the funds to go to support. It was going to do something to help with an attorney, or I don't know if it was for this case or his criminal matters that he was being charged with in another county.
So Mr. Bennett, sounds like you chose to use the money to go someplace else with it. Why is that?
No, I didn't. They didn't do nothing with it. They didn't do nothing with it because I got a program. They won't help me.
Sounds like they did help you. They gave you money and you used it for an attorney rather than send it to your child support.
No, I did not. I don't know. No, I didn't. They didn't give me money at all.
So how long you been at this program now?
I'm not at this program anymore.
So where are you at now?
I'm at I'm in town right now. I'm at where I live now.
Which is where? Which is
In
where?
Jackson. In
You got
Jackson.
an address? Have
Yeah,
you got
I
an
do.
address there? Tell me
Yes,
it.
I do. It's
What is it?
1935 Springport Road, Jackson, Michigan, 49202.
Are you working?
No, I'm not. I'm waiting for disability.
Who told you that you couldn't work? Mr. Bennett, who told you that you couldn't work?
Disability.
Who told you that you couldn't work?
Disability. I can't work because I'm getting disability.
I understand that you want to get disability, but that doesn't mean that somebody told you that you can't work. So I'm asking you, who told you that you can't work?
Disability told me I can't work because I'm getting disability.
You haven't got it yet. Is there a doctor that told you that you can't work?
Yes.
Where's that documentation?
My doctor at the program told me I can't work.
Then why haven't you submitted it to the friend of the court?
I don't got it anymore. I can call the program and see if they can speak to you.
No, this is you. You are the one who is responsible for making your payments. We're not chasing your records. You are responsible for getting that information. And if you don't do it, I'm going to throw your butt in jail. Do you understand me?
Well, it's not going to do you no good to put me in jail.
You've been doing nothing. You haven't given me anything.
I'm going to have
We've
disability.
been doing this for 3 months.
I'm going to have disability here in a couple months.
That's what you say, but you haven't done a single thing that you've said before.
Do you want to phone to the lawyer that I got?
I don't want to talk to anybody except for you. And I want you to get the information that we've been asking for the last 3 months.
Okay, I will.
You've been stringing me along doing absolutely nothing.
I'm waiting on disability. I don't know what to do.
I don't care what you're waiting on. I'm not just going to play this game where you keep stringing me along saying somebody somewhere might give me a disability. I got nothing from you that says that you can't work. I got you bouncing out of programs as soon as you want to. I got you not accepting dollars for the child support and then saying that they didn't give it to you, where the guy 2 months before said we'd be happy to give it to you. All you got to do is apply for it. Everything that you've ever told me has been a lie, sir.
I applied for it and they didn't give it to me.
Everything that you have told me has not come true.
I'm here. I don't know. I'm here.
You're here 20 minutes late is what you're here. You haven't done a single thing and you're late and you've got excuses that don't make any sense.
I was trying to get paperwork, okay? I haven't seen my kid in almost 2 years.
You haven't seen what?
My kid.
When was the last time you paid for your kids?
I'm waiting at a disability and I'm gonna pay off the child support. I'm paid off when I get a disability.
If you want to see your kids, file a motion. That's what everybody else has to do. It's got nothing to do with child support. Those two things do not necessarily go together. You pay because your kids have bills, not because you see them or not. If you want to see them and you haven't, file a motion. Nobody is stopping you from doing that.
I'll get a lawyer. I'm gonna get a lawyer.
Feel free.
I will.
Ms. Kraus, what do we have for a monthly payment on him? Anything?
His obligation is $703 with an arrears balance of $20,342.50. There's been no payment since the order entered.
In the month of September, Ms. Kraus, when's our next, when would be the first date that we would normally have hearings on? Do you have that?
September 11th.
All right, that gives him 4 weeks.
You want the phone number to my lawyer?
No, I do not want a phone number for your lawyer. I don't think you understand what we're doing. I am not your caseworker. I am not going to make phone calls for you.
I'm getting child security. I'm getting child. I'm getting off. I'm gonna pay it off.
Here's what we're going to do, Mr. Bennett. You're going to make a payment of $703 before September the 11th. If you do not make the payment by September the 11th, you will go to jail for 7 days. In addition to that, you will get a letter from your Social Security lawyer as to what the status of your Social Security case is. If that letter is not here by September the 11th, you would go to jail for 7 days. Do you understand what you need to do?
Yeah, I do.
Write it down.
No, that's my Social Security. I don't know.
Payment of 703, letter from your lawyer as to the status of your Social Security disability claim. Do you have any questions about that, Mr. Bennett?
No, that'd be it. Thank you.
No excuses, because you're going to jail if you miss either one of those. Do you understand that?
I got it.
You're breaking up. All I want is a yes or a no.
Yeah, I'm not gonna have.
All right.
I'm not gonna have money, but
Your Honor,
Yes.
was the court able to hear what his address was, as our office does not have a good address and has received return mail?
Yep. 1935, 1935, Springport Road, Jackson, Michigan, 4920. I believe it's 2, but you might want to check on the zip code.
Okay. And would that be in the order that our office is to update that address by your order?
Yes. Yes, please. That's all for today, Mr. Bennett. Make sure you get your stuff done.
yeah, I'm not gonna have money. Yeah.
You're free to go, sir.
All right, we are on the record now for the 28th Circuit Court over here in Blanchard County. We're going to begin today's afternoon docket call by taking up the case of People of the State of Michigan versus John Eldridge Taylor Jr. File number here 23-13730FH.
Commander carry those people.
Robert Hartzell for Mr. Taylor Jones is my lecture. Thank you. Also here before the court this afternoon is Mr. Sean Van. We're here today for a show cause, which is a lot like an arraignment on a request and summons for a probation violation. Mr. Eldridge, I need to read you those allegations and then tell you what your rights are and see how you wish to respond. Upon this request of summons, there are 5 allegations you violated your terms and conditions of your probation. Those are not new criminal charges. They are just allegations that you violated probation. Each one of the counts alleges that you violated special condition 3.10 of your terms and conditions of probation. Those require that you must complete 180 hours of community service at 30 hours per week until fully completed. And more specifically, for each individual count, there's a specific month. Count 1 is for February, count 2 is for March, count 3 is for April, count 4 is for May, and count 5 is for June. You have the right to challenge those 5 allegations at a contested hearing. That hearing would be conducted within 14 days from today's date. At that hearing, you'd have the right to be represented by counsel, which of course you've got Mr. Hertel here, and you have the right to challenge and question and cross-examine any witnesses presented against you, as well as the right to present witnesses, evidence for testimony if you chose to do so. If you're found to be in violation of your probation, you would be resentenced on your original offenses. In this case, you originally were convicted of 3 counts. 1 count was for a charge of operating while intoxicated, which is a misdemeanor punishable by up to 93 days and a minimum of 100 up to a maximum of $500 in fines and costs, and or up to 360 hours of community service. You were also convicted of fleeing a lewd a police officer in the 4th degree. That is a felony punishable by up to 2 years and or up to $2,000. And you were also convicted of attempting to carry a concealed weapon. That is typically a 5-year felony. And while it's called an attempt, and sometimes people get advised that it's a maximum punishment of half that amount, it's not really true. It's actually punishable by up to 1 year, or in the alternative, up to the original 5 years. However, the way it benefits the defendant when they enter that plea is that it reduces the chance of the guideline scoring. Now that I told you what the 5 allegations are, what your rights are, and the possible consequences, I need to see how do you wish to respond. Mr. Hertel, have you had the opportunity to go over these allegations with the defendant?
I have, Your Honor. He's advised me, after I'll phrase it better. He's advised me he would like to take full responsibility.
Okay. All right, Mr. Taylor, please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. You may lower your hand. Mr. Taylor, I'm told through your counsel that you're going to plead guilty to these 5 allegations. Again, we use the word guilty, even though it's not a new criminal, or none of them are new criminal charges. They're just allegations you violated the terms and conditions. Now, if you enter this plea of guilty, and I accept that plea, you'll be waiving your rights to have the contested hearing that I spoke about a few moments ago. Do you understand that?
Yes.
Has anyone made any promises, threats, or inducements to force or encourage or compel you to enter these pleas of guilty?
No.
And are therefore you enter the pleas of your own free choice?
Yes.
As to the 5 counts, how do you plead? Or the court can accept that plea. I'm going to have you tell me in just a moment what it is that you did that makes you guilty of those allegations. First, before doing so, the court takes judicial notice of the terms and conditions of probation. They are contained here in the court file, and I signed them on February 13th of 2024, and then you subsequently acknowledge them on February 26th, 2024. Is it true, sir, that you failed to complete the community service hours as required by your field agent, your probation officer? Why? Did you do any during those months?
Yes, I did.
Okay.
I just fell short.
All right. Mr. Van Amel, why don't you tell me a little bit more about how many you did per month then?
So in the initial 2-year period of probation, there was no set amount per month. It was just, he had that 2 years to get them completed.
I
In
figured.
the initial 2 years, he completed about 20 hours, which is when we did the amended order mandating 30 hours per month.
Yeah.
Since that was signed in January, he's completed about an additional 15 additional hours. So a total of 35.25 hours is what's been reported to me.
Okay. But when was the last time you did any community service hours? Can you tell me how many he did during July or February, March, April, May, and so forth?
I don't have, I didn't bring a specific breakdown with me. He did not hit anywhere near the 30 hours for any of those months.
All right. Thank you very much. And again, you said so far Since this 30 hours a month, he's on 15?
Total, yes.
All right, copy that. Thank you. Mr. Taylor, is that correct? Sound about correct to you?
You mentioned 2 years.
It's pretty correct. I do have additional hours. I found a new place to do community service.
Okay.
With vets serving vets. I wish I found them a year ago. Because the only place I was able to go was Goodwill. Really difficult doing it there.
Right. I should make note that I sit on the board of directors for veteran service veterans. All right, Ms. Carey, you leave us provided on a factual basis.
I do.
Are you aware of any other promises, threats, inducements?
No.
You do the court's compliance with court rules?
I do.
Mr. Hartel, do you agree with all three?
I do.
The court agrees and finds that Ben's plea has been made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant on the record satisfies the required elements of proof. Therefore, the defendant is found guilty of the 5 counts on the requesting summons for a probation violation. Mr. Van Amel, can you proceed to sentencing today?
All
right, one moment here. All right, go right ahead, sir. Thank you.
On the between force offenses, sentencing guideline ranges 2 to 17. On the weapons offense guideline ranges 0 to 17. Positively, he has paid all fines and costs in full. He did complete the initial screening period without any violations. He did receive one violation that was done through a PV acknowledgement for failing to complete outpatient substance abuse counseling. After that acknowledgement occurred, he did complete the CHS program. Program. Like I said, he's only completed 35.25 community service hours out of 180, and that's spread over 30 months of supervision.
Wow.
He has 125 days of jail credit that does not include good time. I would recommend 210 days jail credit for 125 days served, probation terminated successfully.
The original sentence was
150 days jail.
Thank you. Yes, I see that. That jail sentence was issued on February 12th of 2024. The defendant had 4 days of credit at the time. Can I see the PSI over there, Mr. Van Amel? Thank you. While Mr. Van Amel was getting that, Ms. Carey, on behalf of the people. So it looks like he served the maximum time that he could and got the good conduct fund credit. So, all right.
I would ask the court to issue the jail sentence. Thank you.
All right. Thank you very much. Mr. Hartel, on behalf of the defendant, sir.
Yes, Your Honor. My client has asked me to ask the court to consider perhaps giving him a bit more time to get more community service done. We realize there's a bunch of time behind. We realize that he explained a little bit about what's going on with the prior attempts at community service and how he's been working towards getting more. I do believe him when he tells me he has every desire to keep volunteering at the new location. He did show me a sheet, albeit with 2 hours. If the court wanted to see it, I wouldn't mind showing it.
I'll accept it as an officer of the court.
Thank you, Your Honor. I do believe the fact that he has done, if I understand correctly, everything else properly other than the remainder of this community service, not to try to minimize it, but just to also put some light on the positives. I do believe that he is worth giving this opportunity. I know he wants to make a brief statement in a moment. I'd ask the court to factor that in as well. Thank you.
Thank you. Taylor? Any wishes to say?
I had solid work on my head. I understand that I didn't get it done. I should have. Sorry about that. Any excuse has been an excuse.
It was your choice not to do it. It was your choice not to go to Mr. Van Amel and ask for other programs.
I did.
It's a very small county.
I asked him for help to find other places to do it.
Yeah.
Without getting it. Well, I did continue to try to get in there when I could. There were other factors. Like I have a 5-year-old at home. And it's hard to go work for free when I have help bills and stuff like that. But like I said, it's not an excuse. And I'm sorry.
Where are you still working now?
Right now, part-time.
Where's that you're working?
That's for Gordon's Auto Body.
All right.
And then a number of other odd jobs. I mow lawns. I work on small engines.
Mm-hmm. Okay. All right. You said you have a son?
I have a daughter.
Daughter. Okay. You have. All right. That's the daughter. That is now 4 or 5.
Yes.
Right,
so it's difficult to find a babysitter for her, where I have to pay for a babysitter, but I'm not making any money for the main service, so it's kind of a toss up.
Now, where does she live full time? Yeah, did she get? Hold on. Did you end up getting married?
No, I'm not.
Okay, there was a fiance listed here before.
Yes, we're planning on getting married.
All right. So she lived with you at that same address with the daughter?
Yes.
Is that daughter your biological daughter?
Yes.
All right. Well, I don't know what to do. It's lack of performing community service. Community service is a part of the drinking and driving, correct, I assume. You have been on probation in the past. In 2000, your case had happened in 2000, resolved in 2002. You did complete that probation with no violations. In 2003, you were unsuccessfully terminated from probation. In 2007, you were also unsuccessfully terminated from probation in another file. In 2008, yet another file. You had multiple warrants on a file, a misdemeanor file in 2008. You had some probation violations on the case in 2011, including the criminal conduct, not the most serious, but you had some. 2012, you had multiple probation violations, including the criminal conduct. You have a case in the 84th District Court, at least at one time, was still open to get and pay your fines and costs. You have a warrant out. You had another warrant from a case in 2016 down in Troy. Violated probation here in 2017. 2023, this case here occurred while on probation. I don't know what to do. So then I look at the conduct here, and I remember this case once I read the notes. This is when you were pulled over. You tried to flee the police officers. Then when they pulled you over, you refused to roll down the window, or only did it partially by merely pushing your license up against the window. And then they attempted to grab the license, and then you pulled away. And you continue to refuse the officers. You're told to exit the vehicle. Then you put the car in gear and began to drive away. Disregarded a stop sign, jumped a curb, and finally the blood alcohol level was 0.189. All right, well, so all right. The court is going to give some sentence here for some additional jail. One moment here, I'm just going to give you a court roll. How many prior technicals do you have in court?
1 prior.
All right. Pursuant to Michigan law, I cannot actually revoke probation when there's only been 1 prior. So, court must, by law, 771 point, I think it's 0.4. Let me double check that, make sure I got it right in my head. Right in my head, but that's correct. Closes 3771.4B, and therefore I cannot by law revoke his probation. The court will continue probation as previously set by this court. And that includes all the community corrections hours. You said he already paid all his fines and costs?
Yeah, sure.
All right, well, that's great. I'm glad to see that. When is his probationary term done, Mr. Van Atwell?
We just extended an additional 6 months. So February 27.
All right.
That was to allow for the probation violation proceedings.
Yes. And he had 180 community hours minus the 35 that he served.
Yes.
All right. Court is not going to add an additional jails. It's 150 days, 125 days of credit, which means you've already served that. The court's going to increase the period of community service to 210 hours. You've got until February. Don't fill it up by February, then. And if they mean the Department of Corrections brings through probation violations, then you can expect to go in jail. Oh, we got till the end of your period of probation. You better get cracking. Anything further, Mr. Van Atwell?
Does the court wish to maintain the 30 hours per month or just until the end of probation?
Well, hold on. So I've got how many months now? 1 second. Well, that's still 6 months. So I'll leave it. Tell you what.
So he has 6 months to complete it.
I'm going to say he's got
180 more hours.
He must do at least 30 hours per week or per month. Right? He has to complete them all before he's released from probation. If he hasn't completed them all by the end of his period of probation, then if you all choose, you may present to the court a request and summons that will continue his probationary period until that is completed, and you can expect more than likely some jail time. All right. Mr. Van Atwell, I'm sorry, Mr. Hartel is going to obtain from Samantha over there 2 copies of 1 document that tells you that you have the right to appeal the conviction and sentence in that case. You're going to place your initials on 1 copy of it with no matter election or waiving your rights. It merely acknowledges your receipt of a copy of the document. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal is done by filing an application for leave. If you choose to file an application for leave to appeal and you want to appoint an attorney to assist you, you may complete the bottom half of that document and return to court with this completed in. So if you choose not to appeal, you may simply dispose of your copy of the document that you're going to take with you. I encourage you to reach out to veteran serving veterans. They have some cross-country meets coming up in the next few months, and I know they need services. Thank you. We are adjourned. Mr. Van Atwell, you're assigned, sir. Thank you. All right. And the ranges will include the additional dates of March 4th through March 27th for a total of 24 days. And March 30th through August 13th, which was the additional 14 days we mentioned earlier. Add that to the 16 days, and the defendant now has 54 days of credit. The next question we had here was regarding the defendant's family and whether or not it's correctly listed. I see on CFJ 284, page 15, there have been some additional names added in some birthdays, or sorry, ages. All right. Any further allocution, Mr. Hartel?
Yes, Your Honor. I'm not sure if it's added to what you have there or not, but in employment, my client did advise me that while he was absconding, he did start employment at the Marina, and I confirm that's the actual name of it, is the Marina in Grand Haven. He started there, I believe, May 30th, if I recall correctly. He hopes to return to that employment, and he makes $26 an hour at that employment.
All right, thank you. Mr. Denow.
Thank you. We have no objection to the proposed corrections and additions to the PSI report. The guidelines are, as the court is aware, 5 to 23 months. The defendant did plead guilty to possession of methamphetamine as well as resisting of charging. The brief facts involved this occurred back in February of this year. There was a call from defendant's wife or former wife had called, law enforcement had responded, and then ultimately encountered the defendant's vehicle. He did flee, and ultimately he was found with a glass smoking device with residue. There was a scale, and defendant did acknowledge just smoking methamphetamine recently. As part of the plea agreement, the people did have a Kilbrew agreement to a year cap. That we believe that was appropriate. We still believe that if the court were to order a sentence of 365 days, which we would support and recommend, that would encompass some of the violations or the violations involving defendant being AWOL for a period of time. So we would request the court consider following the Kilbrew agreement, ordering 365-day sentence with credit for time served. I would point out the fact that defendant did plead to two felonies in this case. If there were to be any future offense, there would be additional points, considerable amount of points added to the PRVs. And so presumably any future conduct, if there would be criminal conduct, would be a presumptive jail sentence. So we do believe that would be further support for the court consider a 365 sentence in this case, understanding the issues that have come across in this case. And so with that, we would leave it to discretion.
Thank you. Mr. Aldridge, is there anything you wish to say before the court issues a sentence?
Yeah, I know I did abscond, and I know I should have been here. I should have had better communication. It was just one thing right after another. Life just happened. A lot of things happened. And this last year, so much has happened. Between getting over a super toxic relationship, which actually led to these charges. And then my daughter ended up in DeVos. She got one more surgery waiting for a donor right now. She needs lung. You gotta have her lung. And that's where I was. I wasn't running to run from cops or run from the sentence or run from you, Judge. I was running just to be with my daughter where she needed me.
Okay.
And then while I was there at DeVos, I was offered a job in Grand Haven. And we were on our way to the Coast Guard Festival when I got pulled over, and I'm here today.
All right. So if you're able to go to Coast Guard festivals, you're able to see that the court allowed a bond issue back in March based upon issues involving your daughter in Grand Rapids, and then you're able to get a job elsewhere over in Grand Haven, and it wasn't you could have communicated better. You could have communicated, period. Right? So
you're right.
Yeah, I know. Now, all right. So here we go. The court here is absolutely appalled by your conduct. Let me take a look here at your criminal history. As in a juvenile began in 1996. Now you are 46 years of age, and you should know better. You've got quite a little history here. Some of these entries involve dismissals, but we're going to go over 1996 in June, you picked up your juvenile case. While that was still out there, you pick up, or shortly thereafter, 2 months later, you pick up your first adult case. So you had a B&E as a juvenile. 2 months later, you pick up a retail fraud as an adult. You were on bond for that retail fraud, picked up a second retail fraud just shortly thereafter. And while on bond, you picked up a series of other cases that apparently were dismissed. However, then we jumped to 1999, and I see that you were violating probation because you look like you got probation for delivery of marijuana in the middle of all this. So while you had several cases pending, it looks like they were all dismissed as part of you pleading guilty to a delivery of manufacture of marijuana. All right, so then 1999, while on probation, you get a minor offense, expired license. Okay, but then that's followed up immediately with a driver license suspended. So you've been on, you got picked up for no license, and then you got picked up also for driver license suspended. So you can't seem to file orders, and you're going to be deceptive. Then while on probation again, just all within 1999, you pick up Some more crimes of dishonesty, yet another property crime involving a breaking and entering, plus you had a concealed weapon. And that's where you get your first prison sentence. You're on parole. And it looks like you got parole. Then in 1990, also 1999, you had 2 beatings. Huh. So you had 2 different B&E cases, and each got you a prison sentence. 2019, unregistered vehicle, not a big deal, but this just means that as long as you think no one's paying attention, you're going to try to get away with stuff. Looks like you had a couple warrants out there for failing to appear in the file. 2021, you pick up, again, driving license suspended, not a big deal, but that tells me that when you think when no one's watching, you're going to do what you want. In fact, in 2021, you picked up yet another one of those. But again, that one was dismissed. Looks like it's part of the plea agreement and some other files. 2022, back to violating property crimes, and you get a 4th degree arson, and that one was in front of me. You got 18 months of probation, and you had violations. Back violations of the same nature. You had meth and driving license suspended, so forth. All right. In 2022, while on bond, you had another driving license suspended, again, deception. 2022, while on probation, you picked up a second one. 2023, now we're here for possession of methamphetamine. And let's see, now we jump down to 2026, earlier this year. Now, here's what's really important. This offense date for the domestic violence occurred on January 28th. Now, it was largely skipped over when everybody talked about the PSI, and that's okay. Underneath the description of the offense here, this offense occurred on February 11th. And it was in regard to your ex-wife calling because you were in violation of a PPO. Now, I'm the one that gave that personal protection order. So what I'm seeing here is repetitive issues with you complying with my orders. That file was number 26-32415-PP out of Wexford County. And on January 28th, I entertained over in Wexford County a petition for a personal protection order ex parte by Christina against you. And in there, she talked about you getting into a vehicle, assaulting her, punching her, and if I remember correctly, she was pretty bruised up. So I issued that on the 28th after she got this, after the assault that occurred here in this one file. And that means within days, you were violating the personal protection order that led to the police responding here. Now, you could have been charged with violating the personal protection order. You could have been charged with contempt. You could have been charged with further stalking. Because you weren't convicted of it. That starts to make me believe there that the guidelines are inadequate because they're not fully grasping this. Then you get graces from the court and you're going to do what you want till you get caught. You abscond on bond. Apparently you had something up or and you had this case still pending over in the district court. No, I'm not going to accept your excuses. They're not excuses. We were willing to work. I was willing to work with you before. You didn't show up for testing. And you absconded for months. You were doing it for your own good. I don't believe that you were doing it necessarily for the care of your daughter. Because when it comes to your daughter, if she has medical issues and issues, then I have sympathy for her. But I definitely don't think you were doing a good job. You're an abusive person, stalking, breaking and entering, property crimes, drug life, drug history. No. When I hear stories like this, I think I'm doing a better job for your child than you are. Because you are not going to go spend time with her. At least not right now. And he'd been dealing with methamphetamine now for 15 years, 16 years. Maybe starting marijuana 30 years ago at the age of 16 was not a good idea. Because why? Because that impacts your brain development, and at that age. And that's probably why you've been on this long history. I'm not trying to punish you for that necessarily, but I look at this and I say, I've got a defendant who's got repetitive acts and crimes of dishonesty, thwarting any authority, driving when he doesn't have a license, doing whatever he wants, disregarding orders of me and of a court. Don't go near this person. And you did. Within days of me, within 2 weeks of me giving you the first PPO. And one moment. It says here you may not have been aware of it, but I'm going to tell you, I issued it. I don't know if my file here includes a copy of the proof of service, but the fact is I ordered one, and you're a danger to people. It may be a toxic relationship, but it appears to be that you are an equal part of the toxicity. And you're using drugs, and you will not obey this court's orders. I don't care. I was willing to work with you the first time. I'm not now. You're going to have a chance to withdraw your plea in a minute, because there's absolutely zero doubt in my mind you're going to get a prison sentence for me today. You violate bond, you violate probation, you do what you want, and you commit crimes of dishonesty and drug crimes, and you disappear, and you think that there are good excuses. Well, if you go out and get a job, you can call this office for community corrections and report on your bond. If you can't, that's your choice. This court sentences the defendant to a $68 state minimum fee for each one of the, and then you resist the law enforcement officers. They're just trying to do their job. Oh my gosh. While you're there, violating a personal protection order. Two $68 state minimum fees, one $130 crime victims' right fund fee. And based upon the entire history of this case that I've covered quite well, seeing that bond doesn't work, probation doesn't work, jail doesn't work, even prison hasn't worked. The sentence is definitely reasonable, proportionate, that I'm going to sentence the defendant to a prison term of 20 to 120 months for count 1. As to count 2, this court finds reasonable grounds based upon all those factors discussed to exceed an intermediate sanction cell. And again, the court sentences the defendant to a prison term. 1 second. That is 16 to 24 months. That is the statutory maximum. It is within the guideline range, even though the guideline range is an intermediate sanction cell. The court again finds there to be reasonable grounds to give a jail sentence and even to give a prison sentence, which is even allowed within those statutes that cover intermediate sanction cells, because I have found reasonable grounds and because I find the sentence to be reasonable and proportionate. The defendant has the right to withdraw his plea based upon the Killebrew agreement. Mr. Hartel, what does your client wish to do?
Ma'am, just a brief moment, Your Honor.
Sure. Of course, the defendant is awarded the 54 days of credit as to both counts 1 and 2 that run concurrently with one another.
My client would not wish to pull his plea, Your Honor.
All right, thank you. The court's going to present to the defendant through Mr. Hartel 2 copies of one document. These talk to you about your advices of right to appeal. You're going to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of the copy of the document. This document tells you that you have the right to appeal the conviction and sentence in your case. And based upon the original plea, any appeal is done by filing an application for leave to appeal and not a claim to appeal by right. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Miss Odell, have I missed anything today?
No, so Your Honor, thank you.
Mr. Denham? All right. So I have talked a bit sternly today. That's because I needed to change the tone and tenor of the courtroom. This acceptance of, hey, I'm doing this because I had good reasons. I had to talk that way to say, no, you didn't. You're a father. Do you want to be there? Stop committing crime. Good luck. We're adjourned. Our next file this morning is Michigan versus James Swiderski. File number is 24-3551 FH.
If I may have this.
Sure, go right. Yep, go right ahead. Thank you. Court recognizes before it this morning Miss Laura Odell. She's the agent from the Department of Corrections serving as the probation officer on this file, and Mr. David Denhoughton here as the Missaukee County prosecutor. Also, Mr. Hartel, but Mr. Hartel has permission now to step out of the courtroom with his client. All right, we are back on the record for People versus Swiderski. Mr. Hartel is here on behalf of the defendant, and the defendant is also seated next to him. And of course, Mr. Denhoughton and Miss Odell are present. We also have a probation officer, Megan Johnson, appearing via Zoom today. She has been the supervising agent from another county. Ms. Johnson, are you able to see and hear the court?
I am, Your Honor. Thank you.
Thank you. We're here today for a probation violation hearing. And what are we doing today, Mr. Denhoughton? Or Mr. Hartel?
Oh, I'm sorry. We would accept the people's offer. I don't want to misspeak on the counts that will dismiss. Was it counts 2 and 5?
Yes, people have offered to dismiss counts 2 and 5 with the defendant. It's my understanding pleading guilty to count 1, 3, and 4.
I'm sorry, pleading guilty to counts 1, 3, and 4?
Yes, Your Honor.
All right, Mr. Hartel, is that correct?
It is correct, Your Honor.
Mr. Swiderski, is that how you wish to resolve these, this request and warrant?
Yes, sir.
Thank you. Please raise your right hand. Sir, do you swear and affirm that the information and testimony you're about to provide shall be the truth, whole truth, nothing but the truth?
Yes, sir.
You may lower your hand. Again, we're here today for a hearing on a request and warrant for a probation violation that was filed in this court on July 26th. That included 5 counts. We have an arraignment thereafter, and the matter was set today for a hearing. And Mr. Swiderski, I'm told that you're going to admit guilt to 3 out of 5 counts. Count 1 is one of them. Count that alleges a violation of condition 3 that you must report to your probation officer monthly, and that you failed to report to the supervising agent on several occasions, both in May and June of 2026. Ms. Odell, does that mean he was in an absconder status? I need to know if that exceeded the 60 days.
That was not the case, Your
All
Honor.
right, thank you. Count 2 is an allegation that you violated condition 4, that you must notify the probation officer immediately of any change of address or employment status. I'm told that you're going to admit to that as well. Count 2 is going to be dismissed?
Yes.
Count 3 is an allegation that you violated condition 2.8, that you must complete outpatient or residential substance abuse treatment. That one I'm told you're pleading guilty to. Count 4 is an allegation that you violated condition 7, and that you hadn't paid your assessments in the rate of $55 per month. I'm told you're pleading guilty to that one. And then count 5 is an allegation that you violated 4.16 for failing to comply with the court order to appear here for a show cause hearing back on July 17th. That one's going to be dismissed. Is that what you understood?
Yes, sir. If I may, Your Honor, I believe the factual basis that we discussed for the outpatient treatment would be under the failure to provide proof of completion.
All right. Is that right?
Well, that is the allegation, although there's some question whether or not it was actually completed, Your Honor.
You guys, I got to know what's going on. So did he complete it? I got to have evidence that he completed it. If he didn't, I'm going to assume he didn't.
We do not know. He has never provided verification. So that's the charge. He
It's
has
the
not
same.
provided verification.
It's the same thing. So, all right, I don't care. If he didn't comply, providing it, you can say whatever you want. I'm going to assume that he did not complete the programming until somebody gives me proof that he completed it. All right.
Thank you, Your Honor.
Are you pleading guilty to counts 1, 3, and 4, sir?
Yes, sir.
All right. Has anyone made any other promises, threats, or inducements other than the dismissals of 2 and 5?
No, sir.
Has anyone made any promises, threats, or inducements to force or compel you to make admissions?
No, sir.
And has anyone promised you exactly what the sentence would be from this court?
No, sir.
By entering these pleas of guilty to these 3 counts, they are not criminal convictions, but they are allegations that you violated the conditions of your probation. If you enter this plea and I accept that plea, you're not going to have a contested hearing. You'll be given up the right to have the prosecutor prove the allegations by preponderance of the evidence, to right to question and cross-examine any witnesses against you, as well as the right to present witnesses, evidence, or testimony if you chose to do so. Do you understand?
Yes, sir.
As to counts 1, 3, and 4, how do you plead?
Guilty, sir.
The court takes judicial notice of the terms and conditions of probation that are contained in this court file. They were signed by me on March 18th of 2025 and subsequently acknowledged by the defendant on March 21st of 2025. Now, when we get to that one issue about providing the report, you can say whatever you want, but just provide it. All I need to know is if you provided evidence of completion. Sir, is it true back in May and June of this year, you failed to comply with all the orders by your probation officer to report during that period of time? You didn't appear at all of them. Is that right?
Right.
Did you appear to any of them?
I appeared to quite a few of them. I had phone text messages with Miss Johnson and myself. There was one instance, the brake line went out on my boss's truck, which they have proof of the brake line fixed bill.
Okay. Okay.
I mean, we have
no, so
jobs lined up, everything.
Yeah, it sounds like it.
And I'm hoping, I'm praying.
Well, hold on. I'm going to stop right there. Miss Johnson, could you unmute, please?
Yes, Your Honor.
Ms. Johnson, please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth?
I do.
In my lower hand. Ms. Johnson, you heard what Mr. Swiderski said. Could you tell me, in your opinion here, in your own testimony or words, how was he failing to comply?
I can, Your Honor. Thank you. Mr. Swiderski is he's well aware that report days are Mondays. Despite knowing that, he's failed to report as ordered on those Mondays, including May 18th, May 25th, and then again on May 26th. On June 15th, he was late on June 18th by 2 hours, and then again on June 29th, and then again this month on August 3rd. From my view, it looks as though he may be incarcerated, or he at least is in some bright orange. However, on that date, I had discussed with him that he had to. I apologize.
I'm sorry. No, you're fine. He's not wearing bright orange. That's just a
Okay.
orange colored t-shirt. Thank you. You may
All
continue.
right. Thank you, Your Honor. Again, so just as recently as this month on August 3rd, he had texted me asking if he should report. I advised, due to the current hearing that we're in right now, he would have to communicate with his sentencing county, which he did not do. So that's been the ongoing complication with trying to get Mr. Swiderski to report as required.
What about this count 3, failing to complete the outpatient and residential treatment? What can you tell me about that?
Yes, thank you, Your Honor. On between the months of May and July, I would see Mr. Swiderski or speak with him at least 2 to 4 times monthly. So that would be both in writing via text and in person when he's reporting. On all of those dates, he was ordered to bring in proof or have some kind of proof of counseling supplied. So essentially, over a 2-month period, he was given the grace to provide that information, and he continued to fail to do so.
All right. Thank you. Madam Clerk, can you tell me how he's been doing on how much he owes on his fines, costs, and assessments?
I do not see that he's made any.
Should you just tell me what the balance is?
The balance right now is $1,557.60.
All right. Thank you. All right, Mr. Denham, I wasn't going to go down the road of asking any more questions. I wasn't going to get a good response, but do you believe that there's sufficient evidence now to find the defendant guilty, counts 1, 3, and 4?
I do, Your Honor.
Are you aware of any other promises, threats, inducements?
No, Your Honor.
Do you believe the court's compliance with Scroll 6.445?
I do, Your Honor.
Mr. Hartel, do you agree?
I do agree.
The court agrees and finds that Bennett's plea today is made freely, knowingly, and fairly. The court further finds the testimony provided by the defendant barely under oath, but also the information provided by the clerk, as well as the information provided under oath on the record by Ms. Johnson, the probation officer, in addition to the terms and conditions judicial notice taken from the file. The court finds the defendant guilty of counts 1, 3, and 4. Can we proceed to sentencing right now, Ms. Odell?
We can.
All right, thank you. Can I see the original PSI? And before you begin, and I know he had a prior probation violation that was back in February of this year. It looks like he was found guilty of 2 technical, 1 and 4, I think. And then did he have also a written acknowledgement? Is that what I thought I heard?
That's correct, Your Honor. Mr. Skwiderski signed a PV waiver acknowledging use of alcohol.
Okay. So he's got 3 prior technicals.
Yes.
All right, thank you. Your recommendation?
Mr. Skwiderski has just not been able to comply with the most basic conditions of probation. He was granted release from jail to residential treatment on 2 occasions.
Twice?
Twice. Once initially after initial sentencing and once again after the last formal PV sanction. Did
he complete them?
Yes, those are both completed.
All right.
Yeah, the outpatient
Good.
was not. That was required after residential. So at the last probation violation proceeding, Your Honor imposed 180 days jail. Because of those 2 releases to treatment, Mr. Skwiderski has not even served that full sentence, and he has 105 days of credit.
All right, thank you.
Due to noncompliance, ongoing noncompliance, I would recommend that a jail sentence be imposed and that probation be discharged unsuccessfully, Your Honor.
Thank you. Mr. Denham?
Your Honor, based upon the number of violations and the history of noncompliance over the course of the supervision, we would support the recommendation and we would ask that court to consider a 365 sentence with credit for time served.
All right, thank you. Mr. Hartel?
Yes, Your Honor. Just so the court is aware, my client and his moral support who joined us in the courtroom today advised me that his mother is planning on making, I believe, a payment in full.
Today.
For the amount. It may already be pending, I'm not sure. But just so the court is aware of that, I find that the fact that all 3 of them are saying that to be rather consistent. He's also advised me as that he helps them with not only their daily living because they are a bit older, but that he also helps them on projects. I believe they have some rather large projects coming up.
Projects come up.
And I don't doubt he'll want to testify a bit more about that in a moment. But I would ask the court to consider, knowing that that payment is in the pipeline, that he does have these things going on, and that he, albeit perhaps in a phrase that articulately enough that we thank the court for doing what the court had to do to get the other testimony in, but he came in here today with the desire to take responsibility. He still has that desire, but I believe that he is a good candidate to have another chance at probation. I know he's been given lots of chances. But again, that payment is in, I don't want to say in the mail, but it is pending, just so the court is aware. And again, if the court wanted to confirm with these 2 fine folks that he does help them, if there is work, they are more than willing, if the court wanted, to state so on the record. Thank you.
Mr. Skwiderski, is there anything you wish to say, sir?
Yes, sir. As Mr. Hartel was explaining, I've been with Bob and Barb for their fencing company that they have currently. I've been with them for on the other side of 20 years, and Bob has taught me a lot over all these years, and he's getting up there. I'm his right hand man. He needs me out there on the job. You know, I know what I'm doing. I have a lot of years of experience in the fencing field. And I asked and begged of the court for, the understanding so I can get back on the job this afternoon with Bob, and we got a lot of things to do.
Okay. All right. Thank you. Well, you violated bond or probation, I'm sorry, several times, which I'm going to take a look here at your criminal history. You failed to enroll in the random drug testing in this case and with community corrections. You missed random testings in early 2025. You have in your prior criminal history multiple probation violations, so we can't be too surprised here. The law says that I'm going to give, courts are to give probation where we think that the person's not likely to reoffend, but yet again, the law also says that when there's an intermediate sanction cell, there's a presumption of probation and not so much jail, but I did find reasonable grounds because I definitely had it. So you've got, I'm going to take a look here. In your conviction history in 1997, you violated district court probation. 1999, you picked up additional charges while on probation. You made it a month, violated probation, picked up more charges. A few weeks later, you made it and violated probation again with additional new charges. 2000, again, while on probation, you picked up new charges. And you had multiple bench warrants and probation violations there. 2001, you violated probation. In 2004, you violated parole and you picked up more charges and of course had multiple violations there. 2009's conviction had multiple probation violations. 2012, you also had multiple probation violations. In fact, you picked up entry number 11 of 14 while on probation. And then you made it just a very almost a year before you violated, again, committed more criminal activity. And then this case here occurred within a couple of years after being discharged. But in your last case for the delivery charge, delivery or manufacture, you had at least 5 different violations. I don't know what Missaukee County Circuit Court is doing, but your 7411 stat, and I'm not picking on the judge because they know the case better, but when you had multiple violations, they still let you get your 7411. Not here. You gave you every chance. I'm done giving you chances, sir. So you have an intermediate sanction cell of 0 to 17. You have violated our probation multiple times. In fact, you have almost never ever once completed probation successfully or parole successfully. And you had multiple bond violations. This court is done giving you chances, sir. So this court is well within its right to revoke probation, which it does. I sentence you by taking the same original fines and costs. However, Madam Clerk, I'm going to add $1,000 to the fines. That increases the whole total because you haven't even paid anything in this case. But apparently, I don't care. You only do it when you're caught and you're sitting here in the courtroom. You haven't done it yet. And right now is the moment it matters. If you got people to work for and go do some work, why the heck haven't you paid the money? I don't know. Instead, you keep making up excuses. You can't comply with the probation officers telling you what to do. Everybody here is trying to help you except for you. So,
I'd like one more chance, Your Honor.
No. Oh my gosh, no. The sentence now of the court is a prison term of 13 to 120 months. The defendant gets 105 days of credit. I find that it's reasonable and proportionate and that there are reasonable grounds because you cannot comply with bond, with probation, with parole, with even being let out while you had work release. Nobody mentioned that. You had work release. Why weren't you working and making payments? And by the way, what's a little odd here is I know everybody reached an agreement where you pled to only 3 counts. You already had 3, you only needed 1, it didn't matter, and I can make a finding by a preponderance of the evidence that you committed all the other ones. Now, I'm not going to find you guilty of them, but I don't need to. But I'm going to take them into consideration here. You didn't appear. I know you didn't appear. How do I know you didn't appear at the original show cause? I was the judge. It's on the record. I don't understand at all what you think you're doing. But I'm going to make sure, because what I'm looking at now is deterrence. Mr. Hartel is going to tell next. He's going to make sure that his office, if they don't already do it, I'm sure they probably do, they are going to tell their defendants, if the judge lets you out and gets you to rehab twice, you better do everything he tells you to do. And when you don't, it's your own choice. Defendants, I often let them have the keys to the jail cell. You had them. You threw them back multiple times. Sorry you failed yourself. That was your choice. Have I missed anything, Ms. Odell?
No, Your Honor, thank you.
Fines and costs are preserved, and fines and costs, by the way, are a condition for parole. Make sure you put that on there, Tina.
Okay.
You're receiving 2 copies of 1 document. You're going to place your initials on 1 copy. Doing so neither elects nor waives in your rights. It merely acknowledges your receipt to your copy of the document. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the original pleas in this case, you have only the right to file an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the document, the copy that you're taking with you, and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. I really hope you do the right thing. Use your time wisely. If not, stop coming back here and complaining and blaming everybody else. We're adjourned.
Stop coming back here and blaming everybody else. Words to live by. Words to live by. No matter where you are, especially, most especially, when you're in court. Right, chat? Wrong window. I'm embarrassed. I don't know how to do things right. I knew how to set it up right to make sure I didn't do that, but I didn't do it. Ladies and gentlemen, that's all we have for tonight. And it is Friday. There will be no normal court tomorrow. There's first appearances and arraignments and that type of stuff, but we're not going to be watching any of that tomorrow. On Saturday morning, we have Judge Mogan and Judge Webster on deck. Tomorrow night, Saturday evening, we have Judge Johnson on deck. Then Sunday, Judge Rock. Come on by later on this weekend. Find something that you want to watch with us. We'll have a live chat going. We'll be live. We'll be doing all our stuff. In the meantime, I want to say a heartfelt thank you to quite a few different people here. And I'm going to start these credits and change the screen. And I want to just say, first off, Wendy Greek, thank you so very much. Charlene Tutt, thank you so very much. Oh my dear Lord. Another one, I'll get to that in just a minute. Charlene Tutt says, for the GOAT of YouTube, your streams are the best. Bah. Thank you. Darth Steven snuck one in. I thank you so very much for that, Darth Steven. X25 for Alice B. Cokeless Brownie. I don't understand that, but it sounds interesting. Ties for the Cult of Iro Uluvatar. Thank you, Jim Arger. And Kurt Smith came in late with a really big $10 super chat saying thank you, Lone. Thank you so very much, Curtis. Thank you. This place is nothing without you folks. You know that? This chat right over here that runs along with these videos is half of the video itself. So if you're watching it after the fact and you didn't turn on the chat, I would encourage you to rewind turn on the chat panel and enjoy the chat because it is informative. It is interesting. I love the chat. Mama loves the chat. Everybody loves the chat. Thank you all so very much for participating in chat tonight and watching the videos with us. I am your Lone Wolf Moosehole. I am the host of these little get-togethers. I am your curator for this little archive of CourtTube on the web. I'm just an old cat and a wolf too. Blah, 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 blah. Thank you all very much for hanging out with me. I will be back in about 13 hours. Come by and check out what we got. It's all interesting stuff. Darth Steven, Deplorable, thank you so very much. And as Darth Steven says, bye. He says, make the wolf meow. Not right, meow. 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 And remember, only you can take a bite out of crime. Bye.